truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you, for the reasons that we stated in our multiple responses to their multiple amended motions, to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens? All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. The court's going to prepare a written order, and you'll have it before the close of business tomorrow. The courthouse may be closed, but I'll be here working.
Jim, for the record, there's two exhibits that I tried to introduce. They will be admitted
Correct.
for the record.
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. State what, if any, positions do you have with regard to the restraints?
Again, we've already decided that issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already, and unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
Clarification, but you know, she's here today and she's in handcuffs, so she has difficulty writing. She has.
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger, and people automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Is the prosecutor going?
No, that's your table, sir.
Okay, closest to the jury. So she'll be sitting here with the other 2 lawyers and I. And the only time they're going to see her walk in and out is she's always going to be in the courtroom.
They're never going to see her walking out.
So the only time is when she testifies. So I guess I don't know if you have leg restraints that she can wear and walk, but we believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny as she's walking from the defense table to the witness stand to testify on her own behalf. But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here.
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. You know, there are times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative, and she understands the importance of behavior, and I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Any further as to that issue?
I don't believe that's case law authority on the issue.
All right, thank you very much. With regard to your request for clothing in that, you can certainly go to the jail and provide, have whoever it is that you want to meet with her in the meeting area to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it will be transferred with her in the morning on each day of trial. With regard to the appearance issue, do you have any other further arguments?
just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair cosmetics to be clothing without restraints for trial, just the arguments.
And the Stella case that you cited spoke to being dressed out in prison garb. It's really address prisoner shackles. It doesn't address any beautification or anything along those lines.
I just think it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm going to have the two paralegals here. I say paralegals. One's a lawyer now, and the other is a consultant. But the females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Can she be allowed? Can the two females on the team can they be allowed to apply some type of makeup to Ms. Smith?
Steve?
You don't have any dog in this fight?
Tu casa también es un sauna. Hazla con Isoar, el mejor aislante para tu hogar.
I've never heard of it happening. That doesn't mean it's not permissible, but
If you want to try to do it here in the courtroom, that's fine. But be advised that, when we start court, we start court. So, and I intend on starting at 9 o'clock every morning. So I'll have pleas every morning in other matters, because the court still has other business at 8:45, and I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can perhaps someone attend travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secure areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request for removal of the leg restraints. The hand restraints will be removed. I think that it falls under the same analysis.
It needs to be done in the courtroom.
Yes, sir. Then the last item teed up for today is the, yes. So corrections in the Orange County Sheriff's Office has just advised me that the concern is if makeup is affixed and she's taken back downstairs and taken back to the Orange County Jail. They don't know if it's contraband, they don't know what's placed on her person. That's the concern. I understand, but DOC and Sheriff's Office tell me they can't do it because of the concerns that were just outlined. After she's returned to the Orange County Jail facility. We'll get an order with regard to the restraints no later than tomorrow. Moving out of the state's request for protective order, I've reviewed that. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors in the state attorney's office.
I did not realize that was
Yes, my JA had emailed all y'all, I think last week after it was filed, and said this would be added to the hearing form. I just had to tell them nothing for this one. I had emailed y'all and said that it would be addressed today.
listing it's the third amendment witness list lists certain people as witnesses. Custodian of records, Orange County, Office of the Attorney, domestic violence supervisor for the Office of the State Attorney.
¿Qué querés?
For the Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or cleaning product
requiring prosecutors to disclose work product in any criminal prosecutions is violated of Florida law.
Which, as you know, on a notice of intent to have a spouse submit self-defense. And we have listed and plan to introduce the fact that George Coyles had been arrested, I think, 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed against Mr. Coyles. And it's going to come out that Sarah Boone had requested the charges be dismissed. And I believe it's going to come out probably through testimony that that's one of the conditions, or that's one of the things that they're trying to do behind the ongoing and then get the charges dismissed as a spouse. It's a common thing. So ultimately, the jury's going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether the prosecutor gets drop. Yes, they are to consider what the victim wants. They are to consider their request, but ultimately, the state attorney has to make that decision whether the case is dismissed.
What are you going to be asked? How would that not be?
Well, if it comes out that she went down there and requested the charges to be dropped, and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charges to be dropped and they would. But in fact, the ultimate call is the state attorney's office. They don't have to drop cases even if the victim claims it. So just that decision by the state attorney to drop it was their decision. They considered the victim. It was their decision to drop it, and their power and authority to do so, not the victim.
I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody. It does not matter whether the defendant's aware of it. The notion that this sort of evidence would be much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough have victim advocate. All now, I learned while we were at the jail this afternoon, they served with subpoenas by the defense, and we're going to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped the case. That is in the work product. And if they want to get public records about these cases and try to get moved in evidence, then they have to do public record requests or compel discovery from the state attorney's office, which I believe we all have. The state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery to they don't even have this evidence. We got dropped last Friday the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. Defendants have these things that are getting dropped on the stage for years. We're just getting dropped on this Friday. And now we are having to combat subpoenas and requests documents. With this opinion work product, people that they listed didn't handle those cases or make those decisions, but that is the ultimate protection of why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. That evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is going to come in, but it cannot be coming in through any work part of the assistant state attorney.
intend on arguing that's not cited in the motion, please provide me that before your meeting tomorrow. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, state if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge and potential penalties, everybody's on the same page as to what those are. Okay? If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance. Appreciate it. All right, thank you all very much. We'll address scheduling of any motions on Monday, and it may be a circumstance where the court could identify earlier that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn over to you all, which would include your opportunity to run by on any defenses that may be being raised in this case. So it may be we make that now, and come back later in the week so we can have those motions to actually get that done. Once we get that done. Okay? All right, thank you all very much. Thank you, everyone. Thank you.
Cosito.
And would you please state your full name? You're going to have to speak up or move the mic.
Sarah Boone.
That's right, y'all saw it, y'all heard it, folks. Sarah Boone took the stand, and we're talking about it in today's video. Hello, subscribe, I'm back in supper. The supper back there, and our little mascots right here in my arms. It was just nappy poo time, and now we are slowly waking up, and it's a party essential time up in here, if you will. But it's also party essential time for another reason. Y'all, Sarah Boone took the stand today. Now, we did a live chat to watch the hearing. Y'all, when they were like, we're calling her to the stand, I'm talking, my mouth hit the floor, and we were all like, what? Okay? So I implore you, whether you go to my other channel and watch the live chat there, or you just go to Long Crime, which we were looking at the clips through today, Court TV did it as well, and watch the hearing, you're going to want to catch this one, because it's like a little taste of what's to come. Now, all I've done for this video here is I've gone through and gotten some clips. When I say some, there's actually several. And I'm focusing mostly on some of the questioning of the detective who we met in interview, and then also obviously a lot of Sarah's testimony. But this was a very lengthy hearing, a motion hearing, mostly revolving around those Miranda rights, okay? And Owen, who is Sarah's defense attorney, trying to catch, people up in that and get that thrown out, obviously. So just keep in mind, if you're not familiar with this, case or video or whatever, we are watching the Sarah Boone hearing today and going over it. And Sarah Boone is standing trial on October 7th for taking the life of her boyfriend George by manipulating him into a suitcase and letting him suffocate. So this is just another motion hearing for her last minute attorney Owen to try and get things thrown out to benefit her, of course, right? So what we'll do is I'll put the clips on the screen, we'll talk about them. Now also, before we get into this, I'm going to tell you the volume on this was horrible. And when we're watching this detective, her volume goes in and out. So I would almost implore you to listen to it with headphones, but also be aware of sound up and down and that kind of thing. But just know you're going to have a hard time hearing what she's saying. It's not your speakers, it's her. So you almost have to really listen to this part with headphones in. So just know that.
So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day.
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult to the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation.
Okay. Now I wanted to choose a few clips of her, but first of all, can we talk about how gorgeous she is? I mean, she's coming in there, the 70s, 80s blowout, the makeup. I mean, I'm just like, wow. One thing that's amazing with her is she has this very unaffected, kind of attitude that I personally think is like eating Sarah up, right? So keep that in mind. I also think Sarah's probably absolutely punching air as to how good looking the detective is, right? If you remember, if you watched the interview that this detective did with the other detective, the infamous interview at this point, she, meaning the detective here, was pregnant, and she was constantly coughing in that interview. It drove us all crazy. So this is kind of the first time we've really seen her since then. People, at least like me, just watching through TV. Obviously, I don't know her personally. So seeing her up there, I'm like, oh well, you can tell. I think she's just over this case, like anybody else is, right? So this is where you hear the little clip or whatever where he's talking about when she was a suspect and if this and if that. Again, with Owens, he tries to pinpoint certain things, but I don't know if he's just in over his head, or if he doesn't know what he's doing, or if he doesn't care. Because so many of the things the judge would come back on, and you're almost like, how long has this guy been a lawyer? It's very fascinating, but for now, let's keep going.
But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then once the autopsy was completed the next morning was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized and she went to jail later that evening.
Okay, now again, what they're talking about is the Miranda rights, the Miranda rights, the Miranda rights. Did she read this? Did she do that? I said this in live chat, and I'll say it again. If the detectives had never read Sarah her Miranda rights at all, I would be with this attorney here, like, you've definitely got a case for this. What is at stake is, not really at stake, well, what's at stake is him trying to obviously get major evidence thrown out, right? That would only benefit his defense. There was apparently, I believe, 9 questions, and she only asked 8. Now, there's a bit of a mouth drop or jaw dropping thing here in a second that we'll hear as to why she only asked those questions, but it's the very last question, like, do you understand this? Now we will hear even Sarah get up there and say she knew what the Miranda rights were. It's like her and her attorney kind of contradict each other through very muddled testimony and lacking case law and all sorts of issues with this. Let's keep going.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall specifically saying that,
Okay.
Now this is what I'm talking about here with a little bit of attitude you see coming through from her, the detective, with him. Now she'll get questioned by the state as well. And you often see this where, people, whether it's detectives or whoever, they get a little, how do you say it, like annoyed with the defense. And I think one thing that's annoying with the defense here is it's like he's making something out of absolutely nothing, and everybody kind of sees it, and it's just this lack of preparation for it. And I think it's very obvious to everyone there that's like, knows what's going on and whatnot, the judges, her, the other attorneys, people like this, and it's kind of cringy.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
It's actually not.
I'm sorry?
It's not.
What do you mean by that? It was the card that you read, it was not on the card?
We have multiple Miranda cards at the sheriff's office. So yes, that is the in reference to the policy. Yep, it's the policy.
Well, somebody dropped the ball somewhere. Did you fail to get
Sustained.
did you fail to get the most updated card, or how did that happen? That the 9th question was not on your Miranda rights card?
I've 20.
Have you become aware, as it relates to filing this motion,
I've
have you gone and gotten the updated card?
Relevance.
Okay, so you had a hard time hearing her. When he says about the question, she was like 8. Like the way she did it for me is she was almost like, oh my God, it's a crime, I only have 8. Look, Luke's like, what are you doing? But then when she goes, the 9th question isn't on my Miranda card, but continue. And he's like, what? And she's like, it's not on there. Now she acts like, no, I haven't really gotten, I've become more aware of it, no. Because at the end of the day, by the time you arrive to the 9th question, even with they know what's going on, they know what it is. Now obviously if they're supposed to legally be 9 questions, you need to ask them, right? We get this. But the argument and the way that he's trying to frame this in this I gotcha moment, it's just like, again, it's all on video. She's been read her rights, she understands them, she says this, that, and the other. And we'll hear from Miss Sarah herself here in a moment, but let's keep going for now.
But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone? Okay. Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you?
I have her testimony.
Oh.
Excuse me?
I do not.
Now y'all saw that right there, where she was like, do you have documentation? I have her testimony. Oh, well then I don't remember. We're gonna get into this more because what he's trying to do is to pinpoint and essentially say that they tricked her into coming out. They came up with this false narrative to come get the phone, this, that, and the other, whatever. Now, they will go into case, the other attorney and all this will talk about, look, this is the point, and even her defense will say, this is the point where law enforcement is allowed to basically be, deceptive and whatnot. So, but with her, I'm like this, whether or not the detective is lying and she remembers his phone call, or she's conveniently like, I don't know what you're talking about, wing, wing, wing. What you're going to hear Sarah testify to as to why she called her is absolutely insane, and I would have just let it go instead of admitting to that because it makes her look even more guilty. Now, speaking of Sarah, let's get to the lady of the hour. Let's get old Sarah up on stage here, y'all. Let's roll that first clip.
You called 911? Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
Very confused. It was very hazy. I didn't understand the monumental amount of people that were there, and
The fact, I said this in the live chat, the fact that she opens up with, I didn't understand the monumental, you know what I'm saying, the amount of people that were there, and like, it couldn't possibly have something to do with your boyfriend being deceased in a suitcase, could it? I mean, that might be one reason why there was such a response. This is the part with her that, again, these people like her telling themselves when they speak. It's what's in between the lines. It's what's in the silence between the words. It's what they say first and not second. It's what they say second and not first. It's these little nuances of conversation that show the real version of them. You know, so this whole thing, and also a lot of people find this on the live chat, where she'll really turn on a little girl voice, like, I was confused and scared. I didn't know what to do. I was going to sit here and talk like a little puppy. Let's keep going.
what they were doing with my health. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge, move to strike. This is outside the motion to suppress. I have not made any allegations that her statement is involuntary, mental state, or state of intoxication.
Response?
Okay, now I think we can all agree that we knew she was probably still drunk or intoxicated from the night before, right? However, you heard what the state said. Now I'm just cutting out the more intriguing parts here, or whatever. But the state will go into essentially getting at, and I don't know if I cut the part, but I'll just say it in my own terms of, she can't sit here and introduce this whole thing of like an altered state of mind, and this is why she did this and that. She knows what she's doing when she is getting up there and saying this stuff. She's had all these years to concoct this. So of course she wants to now go up there and say, I was drunk, I was crocked, I was blacked out when I did this, and the other. She's just going down the checklist of all the things that shouldn't happen for a confession and interviews and things like that. Now, personally, what I think will happen is she's going to pull this number on the stand, and they're going to impeach her, they're going to do this. And I don't know if I took the clip out, but he talks about being able to impeach her over this. And he's like, you do know I'm going to do A, B, and C if you say A, D, and F. So keep that in mind as we go forward.
Judge, we're talking about, I'm just getting some preliminary information. Her interrogation was the next day.
The state has an obligation, the case law cited by the state requires specificity in the motions, so it's not a game of 20 questions and surprise.
Okay, this is the day before the interrogation.
I understand that.
We're not talking about
But are
intoxication.
you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25th? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
I'm going to sustain the state's objection.
Relating to the intoxication?
Yes.
He was very meek there toward the end. He said, okay. You know, you heard the judge was like, are you going to bootstrap this and do that, whatever. This is the thing where he comes in late like this and is trying to, wrap all these things in. And again, he is dealing with a client who is throwing anything she can at the wall to try and get away with it. Obviously, anybody would, right? I get it. This is where I really feel like my theory that he is coming in and just going down a list of stuff for Sarah. Whatever Sarah says, that's what he's going to do, and that's just what's gonna happen.
And did she tell you anything about what was gonna take place once you got inside the vehicle?
That she was just going to be asking questions.
Mention it in the protocol. Once you got in the swap car. Okay, and that was recorded for the court to consider. And so she read your Miranda rights? All right.
So again, you heard the thing, she read the rights? Yes, she read me the rights. And then the very beginning, again, look at how Sarah's also just very, yes. I'm too victimized by the system. Remember that. Her language, everything is so, I guess, annoying is one thing because I think it's all put on or whatever. But again, notice how the argument goes back and forth. And I get what they're trying to say is, yeah, technically they read the Miranda rights, but they left something off, which made it, obsolete, basically, what you're trying to say. However, it doesn't do them any good when she gets up here and kind of confirms what we see in the video, right? It's just, this is the hypocrisy of the way they work together that I see come through in this.
Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before? Were you ever questioned about those videos at the scene?
I was not.
Again, Shannon, I was not. I'm sorry. I needed tissue. I'm not terrified. This is painful. I get, and this is the thing, I don't know how the law works. I'm sure it's different from state to state and whatnot. We've seen most of the stuff, most of the videos and things of this nature, the interrogation when they show up, all this, all that. First of all, Sarah's more than willing to talk, right? She had a list when she went to the interview. She was ready to just, talk all night long if she needed to, or all day, whatever. So now, trying to pick it apart, obviously, again, anybody would, but the way they're going through all these things, no, I thought I was there for this. I was misled. I was this. Again, like the detective said, Sarah was the only person there. It is very weird to find a dead body in a suitcase. And the only person that is around is coming up with this bizarre story and seems a little bit cropped, right? Of course, she's going to be a person of interest and they're going to want to check out her story.
What was the reason that you wanted to stay over there the night?
Because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband? And did you do that?
My son, yes.
No.
Now this clip was in relation to her leaving the scene, like that night when it all went down and she was not arrested yet. She went to Brian, her ex-husband, son's over there, she stays the night. And the beginning part when she says, I was terrified of his family, she's talking about George's family. Remember, she says they hate her, they always come after her, all this type of stuff. Well, I'm also like, well, yeah, but right? She knows deep down inside what she did is not right. Of course you're going to be terrified of them. And of course they probably absolutely hated this woman. Imagine the drama that went on between her and George. They were probably like running, screaming from her.
Later that evening, did you attempt to contact Detective Coastal?
I did.
And whose phone did you use?
My husband's name.
You said your phone had been seized?
Yeah.
And you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Coastal told me she or Lowen or both would return back to my apartment to return my phone.
And when did they tell you this?
Before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
Now they'll go into this whole thing, and again, this is the whole dynamic of, they said this, but it really meant this, and it really meant that. Now, here's one question that I do have that I don't think we got answered today in the hearing. Because again, the detective has quite a different story. The detective, this is the phone call where she's like, I don't remember this phone call, right? Do I believe, I think somewhere in the middle is the truth. Sarah calling up the detective and saying, I think you're trying to trick me is completely crazy. But why would she admit, it sounds so bad, why would she admit to that if she's completely lying about it? And I thought the detective was also like, do you have videotape of that or receipts? Oh, you don't? Okay, guess what, I don't remember either. You know what I'm saying? So I think this one could be something where Sarah could be telling the truth, but she also could 100% be lying. But again, either way, it's like when she's lying about something that makes her look even worse. I don't get that part. Now also, maybe the detective, this whole dynamic of, we're going to return the phone, because the detective even said, like, I don't think I would have said that, I forget her reasoning why. But one thing I would question is, if they were like, well, yeah, we'll bring your phone back, and this is the assumption that all this, without saying this all checks out, there's nothing shady going on here, you've done nothing wrong, well, of course we'll bring your phone back. And they probably very would have, or been like, come get it, or whatever the case is. But obviously they find some incredibly damning information on here. Now, for a lot of trying to argue the fact that they already knew this when they took the phone, it was like a trap. I mean, okay, well at this point though, if they knew that, they're kind of, in my opinion, trying to dismantle a possibly volatile situation of, here this woman is doing this, my God, like how do we, disarm the scenario?
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Curtis's private son?
She gave it to me before she left the scene.
And did you call her? Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
So that would have been on February the 24th of 2020? Can you tell us why you were calling her that night?
Before she left, giving me her personal cell phone number, she told me if I were to recall anything, or if I just wanted to talk to her about something regarding the case, for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Now you're going to hear this go back and forth where Sarah's, talking about, oh, they said this and they said that and blah, 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 blah. And this is the part, it is very detailed. So this part, I'm like, and I can see a cop saying, hey, here's my number, give me a call. If you think of anything, if you do this, if you do that, like, let me know. Now, probably what they're not expecting is for someone like Sarah to call and then say, I think you're trying to frame me. Why would you even do that, right? Like, why would you even call to say that? It's so shady sounding. So this is where I'm just like, I don't really know which one to believe on this one.
I needed to see, and they, I guess, ran them upstairs, and Detective Rowan came downstairs. And I thought I was supposed to be picking my phone up over at a particular window. And he says, no, your phone is upstairs. So we would just like you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did.
How did y'all get upstairs?
In an elevator.
So they go up, they use an elevator, and they go up to the thing. Again, this all kind of checks out. This whole dynamic of using the phone as a trap and whatnot. You got to remember, here's the thing, and like I'm looking at it from like maybe law enforcement perspective, is they know they want to arrest her at this point, right? They don't want her running, they don't want her harming herself, they don't want her harming anyone else. So when she comes in, of course they're going to try and sequester her. They want her wherever things are. I mean, I don't know if like what goes on this floor, that's the interrogation room or whatever. But in my opinion, they don't want to set her off to think, oh, what's up. They're also trying to get a confession and trying to get information to be able to charge her. They already have enough for an arrest from what they've seen. So now they're trying to charge her and get as much intel as they can, right? Are they going to lie about it? Sure. Is that great? I mean, I get it. It sucks, okay? But it is what it is, She was all the more willing to talk to them. She had the list. She was ready to,
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants.
His firearm was on his waist?
The entire time, yes.
Okay.
The entire time, yes. I was frightened. I was victimized. when we're in the chat room at this part, it was like, oh my gosh, a cop at a police station wearing a firearm on his belt buckle? What? I absolutely never would have thought that. Like, that is the most bizarre thing, right? But she's definitely trying to obviously just use this as I was coerced, I was forced, didn't want to say any of the things I said, but I felt I had to.
Were you trying to comply with the officer's demands?
In every way.
Were you trying to cooperate? Were you polite with him?
Are you a grade A student? Absolutely! I mean, this is like, I was very practicing the whole time. I don't understand why they didn't like me. And the way she was talking, like, I was fully cooperative. I was willing to do anything. I'm just like, I'm getting creepy vibes off this part right here. Let's keep going.
Is it fair to say that after she read the Miranda rights, and after she said, do you understand the rights that I've just read to you, that she read right into the question? So she never got the answer from you. Do you agree to speak to us now?
I was like, last that.
Sick, trying to look all confused. And victimized her. Sorry I blinked. I was embarrassed that. Was I supposed to be asked that? I'm curious. I haven't known anything about this or learned anything about this myself from all the other roommates that I have, but will you tell me, Judge, was I wrong in this situation? I mean, I'm just like, oh my God. Y'all, the trial can be off the damn hook, okay? 100%. But you see the direction that she goes in on the stand, so just prepare for it.
In their response, that it was a custodial interrogation.
But she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. That she was in an enclosed, small space. She was
That all goes to whether or not...
She was being questioned by two lead detectives, homicide detectives. One of them was wearing a firearm.
Again, he had a firearm. Did you hear the Owens in the middle? He goes, shh, we finish. He's like, look, I'm gonna get my workout in now. I'm gonna get my workout in. But the back and forth like this, y'all, this is just a sample of it if you haven't watched the whole hearing. I mean, they went back and forth on so many different things, and it became painfully obvious. Again, I'm like, either he, meaning Owen, is just, he doesn't care how dumb he looks or unprepared, he's just gonna say it to keep Sarah happy, or he is very unprepared and is like way in over his head. It's giving like traffic court lawyer doing first murder case 5, right? Because some of this stuff, I'm like, I mean, obviously I'm not a lawyer, I'm not in this, but it just sounds so simple, like the way it's presented, where I'm like, this seems like he should like know this already. And again, this is just showing us what her other attorneys probably went through and were not willing to do.
Did you know that you were going to be arrested?
Did not.
Did you know that you were going to be questioned?
Did not.
Are you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Yes.
Were you there answering the questions because she confirmed that this was normal protocol?
That was my understanding, yes.
Yeah, were you there doing it because you were like, yes, I thought I had to. Again, I understand there's this very gray line here, and this is how like false confessions and things of this and whatnot can take place. However, I do not think any of that is the case in this case. I think Sarah did what she did, and she's trying to get a way out of it. And now she's up here trying to talk very soft-spoken and, yes, well, I thought this, and I thought that. Again, it's like, girl, they're looking at you as the suspect because you're the only one there. This is the fact that Sarah's been able to drag this case out for years like this, you actually have to give the woman credit, right? Because it's very simple, in my opinion, right? Non-legal professional opinion. It's like, it's all a video, what she did, or didn't do, I should say, by letting him out in the suitcase. And yet here we are 5 years later still talking about this. Like, I didn't know I wasn't supposed to talk. I thought I had to. let's keep going.
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? And you consumed no alcohol in your home that morning, correct? So does that affect in any way your memory when you testify about the events that transpired between you and Detective Coacher that afternoon?
One more time.
Did the alcohol have any effect on your memory of what happened between you and Detective Coacher that afternoon?
Now or then?
Then?
Did alcohol affect my conversation with her?
So she's doing that whole thing where you repeat something back trying to come up with the answer. I personally think what Sarah's doing is she's trying to decide what answer suits her best. Because obviously one thing she's going with, or trying to go with, is I was impaired, I didn't know what I was doing. Well, she hasn't provided any case, like any pre-existing stuff, but this is the first time. And this is where the lawyer, and I'm not sure if I put it in here, is going to be like, I'm going to try and impeach you on the stand if you, like, this is not going to end well for you. You're bringing this up now where you've not even been saying this. But again, it's her level of probably sitting there and reading certain things and talking to jailhouse lawyers and all this kind of stuff, though she hasn't fired, that are like, no, you need to say you're drunk. The fact that she's like, she probably had hair of the dog or whatever you call that when you get up the next morning and have one dream to function. I mean, come on, right? But you would think she would say that if she did. But the fact that she's just like, no, 1 o'clock and she's still like intoxicated from the day before, which may be legally, like a legal limit. Okay, I get it. But nonetheless, I'm just like, girl, this is not going to work where you're trying. I see where you're going. We'll give you an A for effort. You are a grade A student, but it ain't going to work.
There's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect my answer? I don't.
Okay.
It's been asked to.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she didn't know what.
She does not want to answer that question because she doesn't know if she's so hard trying to toe that line. She's either trying to figure out what will benefit her or she get in trouble. Because it's been asked 3 different ways. Honey, do you have an answer in any which way? Were you or were you not on the defense of alcohol? You brought it up, right? You're the one who mentioned it. Now you're bringing it up all of a sudden. So there's a reason you're doing that. But you don't want to say, I don't know. What's that mean? Were you toe up or not? Okay? That's what we need to know, girl.
Mr. Judge.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she's testified to today, that particularly the things in conflict with Detective Kopsel's testimony, and the court, of course, in a motion to suppress, has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out, so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response.
I mean, there you go, okay? I just wanted to put that in there so we heard the whole thing there. I mean, if this is true, she's done this whole time. These are the games she's playing. And I think what Sarah does is, number one, she tries to throw anything against the wall to stick. but she also, it's almost like she doesn't want to just go with one tactic because that might not work. So she tries to like cast a large net and pull everything in. All the way down to, I'll say I was drinking, I'll say I was doing this, I'll say I was doing that. She's going for every little thing, right? It's a game for innocence. I mean, in a way, it's a game, right? It's a who can move the chess pieces and all this kind of stuff and whatnot. So she's going to get herself in trouble on the stand though. She can't help herself. She is going to get up there and switch something up in the trial, do something, and they are absolutely going to run her through the coals on it. Because she will show her hand, and the jury's going to see it. That's the thing. Right now, she can play all these games, but they've told her multiple times, this is the kind of evidence we're going to bring out on the stand if you go down this road. And she seems to want to call their bluff.
You gave statements to an evaluator this afternoon, did you not?
I did.
And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct? And so you understand the benefit of this motion to suppress being granted?
Of course.
No other questions?
Of course. I hate the way she says of course. I really do. But that sums up right there. You know, he's calling out his bias, her motivation, and this and that and the other. You heard him say she gave different statements. She's changed the story multiple times, right? It depends on what day and what she thinks is working as to how her story's going to go with it. And again, she is going to get on the stand and she is going to pull a number like this and absolutely paint herself in a corner the same way she already has, like with lawyers and whatnot. Now they will go on to address the other motions, the glam squad motion, and basically where they landed on that is, we love the judge for this. The judge is like, she can do her little makeup thing, but it has to be in court before we get started. So you can't take it to the jail, you can't take it downstairs, wherever they hang out, it has to be in court. So we're sitting here like, please Lord, let them air on TV when her glam squad comes out, whoever her glam squad is. We are hoping for a Trixie Mattel look, a RuPaul look, where something dramatic like that, or Owens does her makeup for her, and it looks like, you know, a dude who's never done makeup is putting makeup on somebody, right? So we are here for this. We love the judge for this. We feel like he gave us a little, you know, a little bit of a present with that one, right? So that said, again, this is what hearing that I absolutely suggest going and watching the whole thing. Because it's like a little precursor to what we're about to see, and it is going to be next level. Okay, so let me know what you think down in the comment section below. I do appreciate you if you have watched this whole thing. And if you could, if you don't mind, throw some little sofas down in the little comment section for myself, Roscoe in spirit, Luke, who is now sleeping on the bed, and Bo, who is hanging out with his two bigger cousin brothers, so that we can all hang out, talk about Sarah, all this other crazy stuff here this channel we talk about. And until we do meander down in the comment section, I'll see y'all soon.
I just wanted to say thank you again for watching the whole video, and also thank you for being part of the Sofa Squad. Special thanks to all the Patreon members, channel members from both of my channels, everybody who likes, shares, subscribes, comments in the comment sections. It helps the channel out so much. Now don't forget, I do have that other channel, the podcast channel. That's where we go live, we hang out, we talk. We have kind of sort of a schedule, but just be sure and check it out. I'll put it up here on the screen. Also, if you're looking for merch, be sure to check out my Teespring store. I'll put that up here. And then, like I said in the beginning of the video, if you want to follow me and Roscoe on Instagram, go on, check it out. It's right here on the screen again. But once again, thank you very much. I really appreciate you being part of the Sofa Squad, and I'll see you in the next video.
Don't belong here. It's cool. The Video Gear Command Set. It's the ultimate video game accessory for serious gamers.
Whoa. So that was only 30 seconds long, but that felt like an hour. That was so much information thrown at me. First off, it looks fucking uncomfortable as hell to be using this thing. This kid looks like he's in the middle of an earthquake. Like, you know when you go down a place snowboard on a bike and you're like, that's literally what it looks like, dude. But like, my favorite part about this commercial is that like random, weird, disembodied robot voice asking these like random questions about the Video Gear Command Center.
What is it? Is it a chair? Who means it?
Dude, you know you've got a weird product when even a computer doesn't know what it is. Like, could you imagine if you Googled something and it just said, what the fuck are you talking about, man? I don't know. And I love the fact that the answer to the question
What is it?
didn't even remotely answer the question.
What is it?
10% plastic, 9% attitude.
What does that mean? The chair has an attitude? Is that why he was shaking the kid around? And honestly, the 10% plastic thing, they're kind of telling the future with that one. I feel like with microplastics and shit, we're all fucking 10% plastic right now, dude. My favorite takes are.
Why I started gaming in the first place.
Alright, back up, man.
I started gaming in the first place.
Also, you don't know why I started gaming? Because I got tired of kissing girls.
No distraction, just you